Good morning, everyone, and thank you for joining us. My name is Jason Cogdell. I'm one of the benefits attorneys at ProBenefits. Today is our third client webinar of 2016, and today is a mini webinar, a format we debuted last year if you've not joined us for one of the mini webinars, where we take a basic benefits topic and address a back to the basics type of presentation in 15 minutes. So today's session will be short. It is on a topic that continues to be very relevant, and that is mid-year Section 125 qualifying events. What changes may be made to participant pre-tax elections during a particular plan year, an issue that there's a lot of confusion about, but a rule that's very important, because if we're going to follow the IRS rules and protect pre-tax elections for eligible benefits, we have to follow the Section 125 rules. So thank you for joining us today. In the interest of keeping up with our webinars, just so that we're all on the same page, I want to flip over to our website for a moment. If you use our website frequently, hopefully you do, you'll know that there's an employer page with different tools, including a benefits blog and a list of our webinars. As I click that up, you'll see excuse me, it's not loading. There's a list of webinars on the website that shows the different webinars that we offer on a monthly basis. Also, after the webinar, if you have not registered for the webinar, but you do want a recording of the webinar, we always post links to the recording of the sessions after the webinar. So you can see what webinars are coming up, what ones we've done, and access the recordings there. In the interest of time today, I'm not going to take any live questions, but you can email any qualifying event question or related question to me or to Chris McCauley, our other benefits attorney, at any time. Qualifying events, again, common question, one that has been around for a while, as Section 125 plans have been around for decades and allowed employers to have a written plan that allows employees to pay for certain eligible benefits with pre-tax salary deductions. Since there is the tax benefit both to the employee in not having to pay taxes on the election and to the employer, because the employer, by allowing pre-tax deductions, is exempt from the FICA match on any dollars run pre-tax by the participant through payroll. Since there are tax savings on both sides, there's also a cost of doing business, and the cost of doing business for employers is that employers must follow IRS rules. One of those rules is the irrevocability rule, the rule that says once an employee makes a pre-tax election, whether for health insurance, dental insurance, vision insurance, flexible spending account, health savings account, bank account, although an exception applies for HSA bank accounts I'll mention later. Once the employee makes the election, that election is locked in for the plan year. And plans do not even have to allow any mid-year changes. The IRS does not require that plans allow mid-year changes. Some plans, it's very rare, some plans don't allow any changes to a plan inside the plan year. So the only way the participant selection would change is if the participant terminated employment during the year. Most plans allow mid-year changes, but they have to be recognized by IRS rules. So the cost of doing business for employers is we have to follow IRS rules, and one of those rules is that employees are not able to just change elections on a month-to-month basis or as they feel like it. They can only change among specific qualifying events allowed by those IRS rules. So when can an employee make an election? If an employee comes to the employer mid-year and wants to make a change, again, to a pre-tax election for health insurance, dental insurance, vision insurance, flexible spending account, or any other eligible pre-tax benefit, the employer is going to go through a series of questions. Later, we're going to give you a slide. It's the last slide, and I won't go through it, but there's a full checklist of the specific questions that the employer will ask. Here's the short summary of it. The first question is, was a qualifying event experienced by the employee? Because if, for instance, the employee comes mid-plan year and says, I elected health insurance coverage for my family, I really don't want it anymore. We've been healthy all year. We're paying premiums. We're really not using the benefit. I don't want the coverage anymore. Well, that's clearly not a qualifying event. The employee just can't make a change because he or she feels like it. It must be an IRS recognized qualifying event. There are a number of qualifying events. Here are some examples of them. The common ones we think of are the family changes in status. You gain a dependent or lose a dependent. There's a change in the employment status of the employee or spouse or dependent who's covered. The employee loses eligibility because of going part-time or having a change of role at the employer. Cost changes, the change in the benefit plan mid-year. One of the new qualifying events is enrollment in a health insurance marketplace plan at the marketplace open enrollment. HIPAA special enrollment events, which range from birth, adoption to other specific scenarios. Medicare eligibility and enrollment, leaves of absence. All those are samples of Q&E. So there has to, going back to the prior slide, there has to be a qualifying event for the change to be allowed. Second, whatever the employee wants to do in terms of making a change, it has to be consistent with the qualifying event. I'll come back to that in just a moment. And then third, the change that is made has to be allowed by the plan document. Again, it is possible, although not common, that the employer doesn't allow any mid-year changes. And if so, it doesn't matter what happens with the employee, that change wouldn't be allowed because the plan doesn't allow it. So in the employer's playbook, it is number one, is there a qualifying event? Number two is the kind of change that the employee wants to make consistent with the qualifying event and allowed by IRS rules. And then third, does the plan allow it? I'm going to show you a couple of quick things. We spend a lot of time at ProBenefits in our work with employers on Section 125 plans. We spend a lot of time helping employers with qualifying events. Some of you work with us on your 125 plan. Others who don't, you may self-administer your plan, but when we're assisting the employer with a 125 plan, whether it's the basic pre-tax plan or it's the pre-tax plan that includes flexible spending accounts, one of the main things we do for our clients is assist with qualifying events. A common daily occurrence is the employer contacts our plan administrator, says this just happened. The employee wants to make a change because of X. Should we allow it? Yes or no? And so we help the employer analyze it based on the facts. We have a number of reference materials. Our go-to reference document is what we call the qualifying event matrix, and I put that up on the screen. This is a PDF document. The one I've got in front of me is 23 pages. It goes through all of the possible qualifying events. And as you'll see on the screen, this particular example is the change in employee's legal marital status, getting married. What changes would be allowed under major medical, dental and vision? What about health FSA, dependent care FSA, or supplemental, depending on what type of coverage the employee has, what type of change the employee wants to make. So we have a flow chart we can go through to check to make sure we're analyzing that correctly. You don't necessarily, if you're the employer, you don't necessarily need this qualifying event matrix. If you'd like to have it, we'll be happy to share it. But this is a main area where we feel we can assist employers with these questions because they are complicated and cumbersome, and many times we're giving the employee an answer the employee may or may not want. Now, the other thing I mentioned was that the plan document must permit the reimbursement. Every one of you employers should have a Section 125 plan document, whether it's several years old or it's brand new. You should have a document that says, we have a written 125 plan. We allow pre-tax elections. Here are the benefits that can be pre-taxed. For example, health insurance, dental insurance, vision insurance, flexible spending accounts, health savings account, bank accounts, whatever the case may be. That needs to be included in the document. And then the document will detail what specific qualifying event changes may be allowed. Example, I'm going to flip over to page 4 of this is our standard Section 125 SPD that we use for a premium only Section 125 plan. And question 8 that begins on page 4, and I've highlighted it on the screen, says, under what circumstances can I change my election during the plan year? And this is explained in layman's terms, what changes are allowed, and they're listed specifically: changes in status, special enrollment rights as I scroll down onto the subsequent pages, changes in cost, entitlement to Medicare, Medicaid, change in coverage, and then the qualifying event for marketplace enrollment, which was added by IRS notice in 2014. That's there. So I just say that to say all of these things work together. We're trying to follow the IRS rules, but the plan document needs to allow the change, and we've got to go through the analysis. So just wanted to mention that to you before. One of the things we can do to help you with compliance is to make sure, number one, you have a document. Make sure the document is up to date and allows the qualifying events that the IRS rules allow, and then make sure that any requested change that an employee wants to make meets the terms of the IRS rules and the plan. So as a Section 125 administrator, that's what our goal is. But as a plan that you employers are administering, whether with our help or on your own, then that's the type of analysis that we're going through. So those are the three primary points anytime that a QE is requested by an employee. And I showed you the list of sample ones. I'm not going to go through those in the interest of time, but if you'd like to see more information on any one of those specific QEs or have a copy of the qualifying event matrix, that'd be something we would be happy to share with you. Now, the consistency rule. The change that the employee wants to make has to be consistent with the qualifying event. This is an IRS rule, and it says that even if you have a qualifying event, that it doesn't allow any change to be made. It has to be consistent. Here's an example. Employees covered under your plan, your employer-sponsored Section 125 plan, and your health insurance plan. Employee has coverage, is paying pre-tax dollars for coverage. Let's just call it employee-only coverage. That employee's spouse works somewhere else and has coverage under that employer's health insurance plan, Section 125 plan. The spouse's employment ends, and so the spouse's medical coverage is terminated under spouse's plan. So now, question, can the employee, your employee, make a change? Is there a qualifying event that would allow your employee to make a mid-year change? The answer is yes, because termination of spouse's employment is a qualifying event that would allow the employee to make a change. If the employee wants to add the spouse who lost the coverage elsewhere, that is an allowable change and it's consistent. And so that employee could make that change mid-year, enroll the spouse in the health insurance coverage, and then adjust the pre-tax election accordingly. But what if, because of loss of spouse's health plan at spouse's employer and spouse's loss of job, the employee said, you know what, I can't afford health coverage for myself anymore. So not only do I not want to add spouse, I want to drop my own coverage. Employer, will you allow me to drop the coverage because my spouse lost coverage with his or her employer? And the answer to that is no, because that's not consistent. The spouse losing coverage at spouse employer is not a qualifying event that would allow the employee to drop his or her own coverage. It is a qualifying event, spouse's termination of employment, but that change is not consistent. And you can think of other examples, but consistency, again, is another requirement. Number one, there has to be a qualifying event. Number two, the qualifying event requested must be consistent with the change. Some common things, I'm not going to go through all these in the interest of time. We get many questions. Is financial hardship a qualifying event for an employee to make a mid-year change? No. Is change in medical condition a qualifying event? Unfortunately, no. Legal separation is not a qualifying event in most states, because most states like North Carolina, where we are, do not recognize legal separation. Legal separation is only a qualifying event in the states that have formal legal separation that is filed and recognized by a court of law. Effective date, the bottom bullet point. Most election changes are prospective. Once the employee comes and requests a change and it's approved by the employer, then it takes effect that day or the first of the following month, and then goes forward. HIPAA special enrollment rights such as birth or adoption, do allow the employer to make the change retroactive back to the date of the event. And that's the way a lot of the carriers administer changes as well. So a lot of employers do it that way. But practically speaking, election changes are normally, under IRS rules, effective from the date the change is requested going forward. I mentioned earlier the checklist. Here's the checklist, and I won't go through it in detail, but we'll give you the slide. Here's the checklist that an employer is going to go through. Anytime an employee comes to the employer and wants to make a mid-year change, these are the bullet points that the employer will go through. I gave you the summary version of it earlier. Did the employee experience a qualifying event? Is it consistent? Is it allowed by IRS rules in the plan document? That's the summary analysis. Here is the more detailed analysis. So I won't go through these in detail, but I want you to know that this is the analysis that the plan should go through, and this is what we, as a Section 125 administrator and an extension of the compliance administration of the plan. This is what we will help you do if we're working with you on the 125 plan. This is just a very quick look at the qualifying event analysis. Again, if you have any questions, feel free to email those to us. In the interest of time, I'm not going to take any questions now. This recording will be available if any members of your team were not able to attend today, and this may be helpful. If you'd like a copy of the status change matrix or any other information related to qualifying events or other Section 125 or benefits compliance issues that we can help you with, we'll be happy to do so. Thanks for your time today, and have a great afternoon.